Okay, we'll get going. Hi everyone, my name is Carly Kind and I'm the director of the Ada Lovelace Institute. Um, Many of you will know who we are because you're attending our event and hopefully you've been to one before, but we're a research institute and deliberative body based in the UK. And we have a remit to ensure that data and AI work for people and society. And that means we undertake policy-facing research to understand the societal and ethical questions which arise with the use of data-driven technologies and AI. We are really thrilled to have an excellent panel here tonight, and we are so grateful that you've all joined us to attend, even though I know this time of year is quite busy and probably after quite a long, difficult year, it's taken its toll. So great to see so many of you here. A few quick housekeeping matters. As usual, and you'll be very familiar with this by now, there's a Q&A function at the bottom of the screen. Please put your questions in throughout the presentations and I will relay them to the panelists after when we move to open questions. You can also use the chat function and just be aware that chat usually goes to all panelists and attendees. We invite you to engage with us on Twitter. We're at Ada Lovelace Inst. And you can also find a video of this tomorrow online, which means we're recording it right now for your information. And we're really pleased to have about 70 attendees in the audience today and a very international panel. So I will move ahead and introduce those people to you now. We are really happy to be co-hosting this with the Institute for the Future of Work, and I'd like to welcome its Executive Director, Anna Thomas. We had hoped to have Helen Mountfield here as well, who was the chair of the Institute for the Future of Work's task force, equality task force. Unfortunately, Helen's had an emergency at the last minute and has had to miss the event, but Anna will, of course, be presenting on the Institute's work. Also really happy to be joined today by Benoit Dehaere, who is the Acting Director for Data and Artificial Intelligence at the Office of the Chief Information Officer at the Treasury Board of Canada. We also have Craig Jones, who's the Deputy Chief Executive of Stats NZ, which is New Zealand's national statistics body. And we also have Albert Fox-Khan, who's Executive Director of the Surveillance Technology Oversight Project, which is a US-based organization. And Albert was a participant in the New York City Automated Decisions Systems Task Force, which is a really interesting initiative that we're going to hear more about tonight. So as you can see, we're really taking an international view this evening of what regulating for algorithmic accountability looks like. And we're prompted to do that because of a number of events that have happened throughout the year. In particular, in the UK, we've had a number of kind of high-profile disasters, might be one word, but problems with algorithmic systems, in particular the use of the algorithmic system to decide school results that was deployed by Ofqual earlier this year. And that really was quite a pivotal moment, I think, for talking about algorithm accountability, at least in the UK. There have been, of course, other things happening, such as a long-running debate about facial recognition and a court decision by the Court of Appeal earlier this year, which spoke to what the obligations are on police forces who want to deploy facial recognition technology. And there have been a number of other high-profile instances of public sector use of algorithms and really raising questions around, in particular, accountability and transparency. And so I think there's very much a sense in the UK that we're moving towards answering the question, how do we put principles such as transparency and accountability into practice? And there are a few different options on the table, and the Institute for the Future of Work has been one of the organisations that have come forward to suggest what they've called an Accountability for Algorithms Act, and Anna will speak further to that shortly. So we're really interested in what is the best approach to regulating for algorithm accountability? What can we learn from other countries? What is best practice out there? What should we not do? Where have the mistakes been made previously? And that's why we wanted to invite this excellent group of panelists this evening. So I think we've gained a few more attendees in the meantime, so I think we're at almost full capacity now, and we'll get going. I would be remiss to not remind you, if you would like to use closed caption, you can do so at the bottom of your screen by pressing on the closed caption button. So I'm very pleased to invite, first of all, Benoit Dehaere, who's joining us from the Canadian government. And Benoit's going to speak a little bit about the algorithmic impact assessment framework in Canada and Canada's experience with this issue.
Thank you. So the algorithmic impact assessment is a tool under the Directive on Automated Decision Making, which I'll talk about first to set its context. And this directive was published in April of 2019. So it's a fairly new instrument in that regards. The directive sets mandatory requirements for federal government departments wanting to automate service decisions. So this can include both the full automation or partial automation in the form of making recommendations to officers. It applies to external services. It sets several requirements that are mandatory, such as transparency requirements, so giving a notice that decisions are automated, also providing a meaningful explanation after the decision has been rendered to ensure that there's no black box algorithm that's being used. There's a strong focus on quality assurance. There's regular testing and monitoring, which is required. We need to verify data quality, testing the data to identify its biases. There's employee training that's planned, consultation with legal services, and for some decisions that are deemed more risky, there's human intervention checkpoints, so often called the human in the loop elements. There's also a requirement to provide recourse options, so if clients want to challenge the decisions that have been made in an automated fashion. And lastly, again, once we deem that the risk of the algorithm warrants it, there's a third-party evaluation, so peer review, that's required. So how do you do that? How do you identify which systems are expected to have larger impacts or larger risks? Well, that's where the algorithmic impact assessment, or the AIA, comes from. The AIA is an online questionnaire. It helps assess the impact that an algorithm will have. The result from this AIA will be an impact level from level 1 for low impact to level 4, the highest impact. And we can think of, level 1 could be campsite allocation by the Parks Authority. At level 4, you could have immigration decision, imprisonment decision, those kinds of things that impact people's liberty, well-being, and so on. And this will drive this impact level, how strict the requirements of the directive have to be. So the directive is written in a way that says for level 1, you need to do this. For level 2, you need to do this. So we wanted the mitigation measures to be proportional to the risk of the algorithm. This is important so you can balance the need and the desire to innovate without being burdened by rules and procedures, while still having the rigor that's required when it's warranted. So proportionality. The AIA is a completely open tool that's free to use. The source code is on GitHub, and many cities, countries, corporations have used it already to evaluate their AI projects. If we look at the origins of this directive and the AIA, it's fair to say that's heavily influenced by administrative law. So we don't make a secret of it, it's written right in there. In a way, we think it translates the longstanding principles of transparency, accountability, procedural fairness, and explain what that means in the digital world. So what does it mean for an algorithm to be transparent and fair, for example? The objectives of this directive and AIA are to reduce the risk to Canadians and federal institutions, to have decisions that are more efficient, accurate, consistent, and also interpretable, that the decisions will comply with the tests of procedural fairness and due process requirements, that the impacts of algorithms are assessed and the negative outcomes where they could be present are reduced, and finally, transparency about where we use this automation. We want to make sure that this is information that's available to the public. So it was released in April 2019, but really it came into force, I would say, in April of this year, because we had given departments a full year to get ready, and it's only systems built after April of 2020 that have to comply with this. So from this, we've been in discussion with departments and people having to comply with this, and there's a few lessons I can share, and I'll share two of the main ones. So the first that surprised some people is the level of collaboration that was needed to complete an algorithmic impact assessment and to just automate decisions in general. Building software has never been about just IT. It's always a collaboration between IT and business, but it's even more so for automated decisions. because to correctly understand the impacts, you need to talk to IT developers, privacy experts, legal advisors, the program owners that really understands the target population, and you also need to talk to the impacted users. So completing an algorithmic impact assessment requires a lot of different expertise. So you need a multidisciplinary approach to this. So that was a first surprise, I think, for some departments. The other one was that this automation offered them a unique opportunity to look at their historical data, look at their historical trends of human processes, and often for the first time, take stock of what biases may have been present. So it's not always a pleasant discovery to do this, but it's often a good occasion as you collect the data, put it together to train an AI system. It's a good opportunity to look for those and address them. If we consider some of the issues, well, I would say on the whole, there's been quite a bit of research about this directive. There's a few academic papers on it. And on the whole, I'd say it's fairly well received and it's applauded. The measures it proposes seem to be complete, but there's some questions around the scope of it. So people wonder what is excluded from it. And I think this may stem from a lack of clarity of what it means to make or recommend a decision. So is alerting a decision maker of an unusual condition, is that making a decision or recommendation? What about data matching, finding information in other sources using fuzzy logic to try to present that? So is that making a recommendation? What about assigning a risk score to an individual or a prediction or a classification? Is that a recommendation or a decision? Lastly, I think as you move toward that more the other end of the spectrum, so if the system says you should choose this, but a human reviews and makes the final decision, everybody sort of agrees, okay, now that's making a recommendation. But the earlier ones, it's not as obvious, and we need to have that discussion to educate and to see where we think to draw the line. And for the record, all the examples I gave previously, I would consider them part of what's making a recommendation in an automated fashion. So my team has some work to do to clarify this. So I realize I'm talking quite a bit, so I'll close and summarize maybe. So this event is about how can organizations be accountable in deploying algorithms. I think the directive is a great inspiration for that. And if I were to summarize it, what's the big principles? Well, the first one is transparency about where you're using it and how. The second one would be you need to provide an explanation. So how was the decision made? It shows that you understand the system and that it's fair at the same time if you provide this explanation and everybody can agree to it. Showing that you've done your due diligence in identifying the potential negative impacts. So that's where the AIA comes in. Understand the biases and how you've addressed them and how you've minimized the potential negative impacts of the system. And lastly, it's always providing a recourse mechanism to dispute the decision if you're not happy with it. So with that, I'll turn it back to you.
Thank you. That was super clear and helpful. Thank you, Benoit. Can I ask one clarifying question? You mentioned there you would consider this to be within remit, but you mentioned risk scores, and is it the case that that type of risk scoring or predictive predictive system is clearly within the remit of the directive, or it's still a fuzzy area?
Well, if you ask me, I'll say yes.
Mm-hmm.
But I think there's some maybe attenuating factors around that. So it depends how that risk score is used. So for example, a lot of audit organizations will assign that risk score, then do a sort to get the highest risk at the top. And they'll say, okay, the top 10, we'll go and examine them. By doing that, you've automated the decision of who you're going to examine. So clearly assigning a risk score in that situation, yes. In other situations, it depends how it's used. So if it has a strong influence on an officer making a decision, then I would say yes, because there's factors like automation bias, where if you see a high risk score from the system, you're like, that's likely to sway your judgment and affect it. So it's considered making a recommendation that would be in scope. So in most cases, yes, but there's maybe scenarios where the risk score would not have a bearing on the decision where it could be excluded. Yeah.
And is it the case that a regulator or other government body has enforcement powers with respect to non-compliant government departments, that is, people who should have done an impact assessment but don't?
Well, with the this directive, so we're the Treasury Board Secretariat, and there's several mechanisms that we use to assess compliance. For example, we have what's called the Management Accountability Framework. So on a yearly basis, think of it as a survey to departments where we ask for evidence of compliance with our policies, and it's across all policies that we do this. So as part of that assessment, we can review and engage with departments. There's also engagement with our big IT projects have to come to an architecture review at the Treasury Board. So as part of that engagement, if we notice a automation component, we'll educate and we'll do outreach to make sure that these activities take place.
Great, that's really helpful. Thank you. There was a question in the Q&A about whether or not you might have a link to the directive. Perhaps that's something you could put in the chat if that would be possible.
Sure, yeah, I'll do that.
Great. Okay, let's turn over to the other hemisphere and ask for Craig's reflections on New Zealand's experience.
Tēnā koutou katoa, e hui nei tēnei wā, e mihi ana hau ki tēnā o koutou e hui nei. Warm welcome to you all from bright and early in New Zealand, and it's quite prescient that this conversation's happening today. Actually, as I was driving in, Associate Professor Nessa Lynch from our Victoria University of Wellington's released a report on an investigation, an international report actually, an investigation looking at facial recognition and recognising that New Zealand police now have the capability in place for widespread surveillance of the New Zealand population. They don't identify any evidence that it's actually being misused, but the key message coming through is that they just don't know because there's not a lot of transparency. And so I think that's a theme that you might hear a little bit coming through from the panelists today, and it's certainly something that's been quite prominent in the discussions that we've had as we've developed our algorithm charter for Aotearoa New Zealand. In some ways, I kind of feel like this conversation's been fairly slow in coming. It's effectively talking about the ethical use of augmented decision-making techniques by government agencies. I think back to my undergraduate psychology lecturers where ethics was drummed into you, 25 years ago. It seems some professions, and I want to draw on this because I think a lot of it is actually about professional practice, and in some professions, this sort of thinking is actually quite widespread and has been for a very long time, borne out, of course, by the fact that we used to shock people in the 1950s and so forth in psychology, or train them to be prison guards and beat up on prisoners and so forth. So some of us have been on this journey for quite a long time, but and I guess it's just been accelerated in government by the advancement of the technologies that we have available now, and in some senses regulation being slow to catch up. So it's a good time to have the discussion. For us, we've developed an algorithm charter for New Zealand, which is effectively an opt-in model for agencies that can sign up to the charter, which binds them to certain practices in the use of algorithmic techniques. It came out of a report that we conducted in 2018. So our agency, I should say for context, is the National Statistical Organisation, but it also has been nominated by our cabinet as a role to be the chief data steward for the government data system, which effectively means working across government agencies to lift the quality of how we collect, manage and use personal information. So it's a sort of leadership role across government to make sure that we're behaving in a way that's consistent with the expectations of New Zealanders, among other things. And as part of that work, which was born out of some concerns from a couple of uses of augmented decision-making techniques, partly in our immigration system and elsewhere, to look into how government's using these kinds of techniques. My conclusion of that work, which was conducted in 2018, is that It's not actually as widespread as what I would actually hope. To be honest, I was a little underwhelmed by the extent to which algorithms were being used by government agencies to help in decision making. But what was really clear is that there was really inconsistent use of or inconsistent way in which government agencies were sharing information about what they were doing. So it wasn't really a great deal of transparency in what was being done, how data was being used, what kinds of data goes into the algorithms that are being used. And that caused for me some concern, and certainly for our government some concern, which was really the genesis for this subsequent work to develop a charter that agencies could sign up to, which, as I said before, binds them to certain behaviours to make sure that there's transparency and accountability for how they're using algorithms. So we released that in May or June of this year. We went through a public consultation following the release of that initial algorithm report. There was quite a lot of feedback about that. We developed the charter, which was not an insignificant piece of work and quite a challenging piece of work to get across the line. And we now have 26 agencies signed up to that, which is more than half of our public service departments, including all the big ones that are big users of data. So we're pretty pleased with who's signed up to date, including New Zealand Police, I should add, which is really good. In some senses, it's a little bit too early to know how effective this has been. You know, we've only really released it 5 months ago. Agencies have been relatively preoccupied with other things, it has to be said, during the course of this year. So how effective it's been, we're not quite sure. The elements of the charter are front and centre the requirement to be transparent about what agencies are doing. So we expect that agencies who have signed up to the charter will release information on their websites about what algorithms are being used. Principle of partnership, and that's particularly important for us in our context, and particularly with our Treaty of Waitangi partners. Those who don't know, we signed this sometime after Europeans arrived in New Zealand in the 18th, 19th century. We signed a treaty partnership with our Indigenous population called the Treaty of Waitangi in 1840, and it's really a lot of our activity goes back to how do we honour the commitments that were given under that treaty relationship, and that's particularly important here because the decisions that are made as a consequence of these sorts of techniques often disproportionately impact on Māori in New Zealand who are overrepresented in justice and welfare statistics and on the wrong side of health and education and a number of other indicators as well. So that partnership, particularly with our treaty partners, is really critical to understand how that's being thought about in the use of these kinds of techniques. Ultimately, thirdly, algorithms are about people. They're not about numbers and statistics. People are ultimately impacted by the use of these sorts of techniques, so we need to be cognizant of that. And signatories need to reflect how they are thinking about the impact on people. Fourth, that data is fit for purpose. That's thinking about data quality to make sure that data that's going into algorithms is not entrenching biases that might exist in the system, and is actually leading to fair and transparent decisions. The importance of privacy, human rights, and ethics, and critically, sixth, that there is human oversight of these techniques. As I said, it's ultimately about people, and in some senses, poor practices where algorithms are developed, set, and never revisited, which as context and time changes, that can lead to erosion of what the original intent was if it's not carefully maintained. So that's the kind of intent of it. We released this, as I said, in the middle of the year. We actually received quite a lot of positive views on it, particularly internationally. Actually, there was somewhat more criticism internally in New Zealand, and particularly to the extent to which it reflects the interests of our treaty partners was one of the key pieces of feedback that we got. And that may not make a lot of sense on the surface, but what you need to understand is that there are very different worldviews and systems of knowledge between Western European views of knowledge heavily based in empirical research and so forth, and those kinds of forms of knowledge, and what we call Mātauranga Māori, which is the sort of indigenous forms of knowledge. So it's really important that we as government agencies find ways of blending these forms of knowledge, and that was one of the criticisms that came through, is that this doesn't accurately reflect some of those differences. Various other criticisms and things have been raised, but I think it's probably too early to really reflect on whether those criticisms are actually valid, and I think we just need to allow a passage of time for this to bed in and see what changes it's made in terms of the behaviours of government agencies. In the interest of time, I might stop there and come back for questions later.
That's really fascinating, Craig. Thank you so much, and just really wonderful to hear about the very unique circumstance of in which New Zealand's thinking about these issues. Although I suppose, given that Canada is also in the call, you know, there might be some. It might be interesting to learn at some stage how you're also trying to bridge those questions with the Indigenous cultures. I'm wondering, Craig, if there's anything you can speak to about red lines around algorithmic systems. Has there been any conversation in New Zealand about how you mentioned the police, for example, had signed up to the charter, and I'm wondering whether at this stage you see algorithmic systems being used across the justice system, for example, policing, with equally as you might see in other areas, or is there a sense that there are red lines or areas in which algorithmic systems aren't being deployed in New Zealand because of the charter or outside of it?
No, I mean, as I said, I've actually been a little underwhelmed, although, you know, I think transparency is one of the key things. You know, one of the things I don't know is whether, as we went out to understand what algorithms are being used, whether people, you know, were not as transparent as they you know, as we might expect them to be about what's actually being used. One of the difficulties we've had actually is defining what an algorithm is. I know that sounds a little bit technical, but it was one of the challenges in the work that we were doing. You know, if you take too broad a view of it, every Excel spreadsheet, you know, is underpinned by algorithms. And we're not really talking about that. We're talking about things that are high risk and potentially innovative that might have disproportionate impacts on people if they go wrong. We actually chose to go with a wide view, you know, a wide definition of what does constitute an algorithm, and to make sure that agencies don't get bogged down in bureaucratic red tape as they kind of document every single regression equation that they use. You know, we kind of introduced this risk matrix to make them, you know, to let them think about, okay, if it does go wrong, what's the impact likely to be, and what is the likelihood that something could go wrong through the use of algorithms. And so far, that's been quite a useful heuristic to help agencies think about what sorts of things might be subject to the charter. But as I said, I think in our original algorithm assessment report, we only identified about 35 or so what we called operational algorithms, so things that are being used in the operations of government that might fit into categories like I've just talked, the kind of higher risk ones. That ranges from things like, you know, risk assessments for you know, in the justice system for people coming up for parole, which is pretty widespread internationally, through to, you know, bus route optimization algorithms for the education system to provide more efficient bus routes for, you know, for cost saving or more efficient transport systems for the schools. So there's no real, I mean, it's fairly sort of spread across agencies, and my point of view, who's a champion for the use of data for decision making, I'd like to see a lot more of it safely used, of course. Yeah.
That's great. Thank you so much, Craig. Let's turn to Albert, who is both joining us as Executive Director of the Surveillance Technology Oversight Project, but specifically going to draw on his experience participating in the New York City Automated Decision Systems Task Force, which I think took place in, I want to say 2018, but Albert will tell us more about that. So over to you, Albert.
Yes, thank you so much for having me. And just to give a bit of background, here in the US, our regulatory structure for algorithmic decision-making would be charitably called a giant mess. We have a lack of clear guidance at the federal level, with residual regulatory authority held by the state and municipal governments, especially when it comes to the public sector use of algorithmic decision-making and broader automated decision-making systems by municipal agencies. And so in 2017, originally, the City Council began to address this issue here in New York, responding to the use of rather opaque proprietary algorithmic systems such as Compass, a score system used for pretrial release of individuals who have been arrested, and some other scandalous applications we saw where algorithmic systems were systematically targeting communities of color. And so initially the effort sought to create an open source requirement for all automated decision systems in New York City that were used by a municipal agency. That later was transformed into the mandate to create a citywide task force, which then was formed and actually began doing this work in 2018 and 2019. So while I was part of those conversations throughout and attended the meetings, I was not a formal member of that task force. But I was quite excited initially because this was such a pressing issue. It still is. We had the opportunity to create the first comprehensive regulatory response to automated decision systems anywhere in the United States. And what I saw was that promise and that opportunity, sadly, being systematically squandered, such that at the end of a year and a half, we really had not yet achieved consensus on even the most rudimentary components of a regulatory regime. And so part of this was just the inability to bridge the gap between civil society and public sector entities in approaching the regulatory framework. In particular, we saw strong pushback from law enforcement agencies who are have long been opposed to that sort of transparency when it comes to investigatory techniques such as facial recognition. And I should say, this is all unfolding as these tools are really expanding exponentially. And in the last 3 years here in New York City, we've used facial recognition more than 22,000 times in criminal investigations, including everything from graffiti and shoplifting to really a variety of petty crimes. But we also see ADS becoming part of the fabric of education, healthcare delivery, firefighting, and really it has become a large part of how we deliver municipal services here in New York. And part of the concern was, while we did have agreement that machine learning systems should be subject to a heightened regulatory structure of some sort, there wasn't consensus about the use of some of the lower tech systems, such as the Excel spreadsheets that Craig mentioned. I actually am of a slightly different mind when it comes to those sorts of systems, because I do think that some of the most powerful forms of automation in municipal services, because of the slow uptick of these newer cutting edge machine learning models, ends up being the formula hidden in an Excel spreadsheet that can disproportionately impact over police communities or underserved or deprive resources to a lower income community. And so we wanted on the advocacy side those systems to be part of the framework. We never were able to reach consensus on that. We were never able to reach consensus in part because sadly, the task force wasn't actually able to gain information about how New York City's ADS were operating. So during the course of the task force, we repeatedly asked for just access to the data on what ADS were being used, how they were being used, what safeguards were in place already, to at a bare minimum have model cards or some other sort of set of information about the status quo, because this is a very hard regulatory space under the best of circumstances, but it's almost impossible to create a meaningful framework when you don't have that underlying access to how these tools are already being deployed, let alone trying to future-proof those systems that will be deployed in the future. And that was another thing that many task force members spoke out against. We actually had a shadow report that I'll include a link to in the chat later, that was put out by several task force members and a number of civil society groups, that actually was created as a response to the official report, highlighting its shortcomings and putting forward the alternative framework that we hoped the city could have adopted on its own. Since the task force disbanded in the end of last year, we had an executive order from Mayor Bill de Blasio creating an algorithmic management policy office, which oversees the use of ADS by city agencies. Sadly, that has also appeared to really languish. There's been minimal activity with that agency since it was announced. We haven't actually appointed the the officer who's supposed to oversee that department, and we really haven't seen any meaningful transparency about existing ADS, let alone the regulations we need to push back. This is why we've seen an increased focus, at least in the US, on using litigation under existing human rights and civil rights laws as a way to try to get some regulatory footing, as a way to try to push back against some of the more abusive ADS. But we continue to think that we need a comprehensive regulatory structure. We need that at the city and state level. And eventually we hope we'll see something similar at the federal level. And just because of time, I'll leave things there.
That was great, really concise history. I wondered if I could ask a couple of follow-up questions. I wondered what lessons you would take from the process of defining the framework that you would, and perhaps this is in your report, and please do link that so we can all read it. I think I recall the one, but what lessons would you take from the process by which New York City went about conducting the task force that you think could have been done better, and perhaps other countries, other cities could do better next time? And then are there some like top 3 things from the actual content of the work that you called for as in your shadow report that should be top of mind?
Yeah, I think it really, with ADS, we see such a democratic accountability gap that we believe that any structure that we use going forward, any task force, any similar approach, has to be driven by civil society, by community members, by the public, and it should not be driven by agencies themselves, because they have such a conflict of interest in developing these regulatory norms. And I just think that it creates this just huge chasm in what people are prioritizing in developing these new rules of the road for automated decision systems. In terms of the top level takeaways from the shadow report, I think there's a real premium being put on transparency. One thing that's quite crucial to all of this is just going beyond algorithms as well, and recognizing that training data, other data sets that are being used by ADS, these are all part of what can create bias, can fuel errors with ADS. And so recognizing that simply having an open source requirement or a third-party auditing requirement isn't enough, and we really need to create new mechanisms there to inform the public of how ADS are making decisions about their lives. And then redressability, looking at how we can ensure that anyone who is impacted by an automated decision system has a meaningful opportunity to appeal that decision and any resulting harm to a human decision maker without having to, and having something that is much more streamlined and much more accessible than the traditional court system, simply because if we force people to go all the way to filing litigation in order to vindicate their rights against ADS, it will make it such a potent barrier for some of the most vulnerable communities and really allow dysfunctional ADS to continue.
Yeah, that's great. Thank you so much. So there's a lot in there, and we're getting a lot of questions in the Q&A. So we'll come back, I'm sure, to the New York experience. To round us off, I'm going to ask Anna, the director of the Institute for the Future of Work, now to speak, and in particular to speak from and about a really excellent report that they published recently, and we'll make sure it goes in the chat as well. And I'll let Anna tell you more about that.
Thanks so much, Carly, and for inviting us to co-host this amazing event. I would like to talk about our work in the Equality Task Force and our recent proposal for an Accountability for Algorithms Act. We established a cross-disciplinary task force about a year ago of technologists, academics, lawyers, business and unions. We zoom in on how automated technologies and AI were used at work in some really sort of key areas, and to look at the opportunities and challenges arising from the use, their use there, and how to resolve them. So we've very much come from a work perspective, and we are, I should have said, a charity with a mission to shape a future of better work. As our methodology, we designed up 3 quite detailed case studies covering 3 high stakes areas in which we've seen acceleration actually through COVID, hiring, management and performance. And the case studies were hypothetical, but we used real research and other material in the public domain, and also the expertise of the group, to make sure that they really reflected real uses and real experiences, and also to make sure we could get past some of those kind of transparency and access problems that you've all talked to. So against that background, we pulled out the challenges and the themes and tested the main legal frameworks in the UK for accountability, identified goals and steps we thought needed to be taken to get there, and that did take us to the need for sort of fresh legislation. As I've said, we focused on work and a very sharp experience of work, but I think that what we have found in our propositions and trends may shed some light on similar problems that outside work too. If I can share some of those main propositions and themes that underpin the proposal first, I think that you'll spot similarities in them in all of your experiences that you've spoken to. The first proposition is that although human roles are often obscured, data-driven technologies are very much the product of human decisions. And when you go into the woods of our case studies, you see really clearly that it's humans that are setting the agenda, setting the perimeters, defining the problem, selecting the training data set and variables, and fitting that technical system into the wider decision-making system. And those decisions are the ones that really count, albeit that they are diffuse and often they're hidden behind a language of technology or statistics and spread out across multiple roles and organisations. Even with machine learning, that it's an aggregation of algorithms to achieve an outcome set by an initial algorithm designed very much by humans in this way. And that's something that we feel is sometimes lost in some of the wider debates, and that part of our task is to recognise this and to reaffirm human agency. The second proposition that we came to through looking at the case studies really closely, which is really more debunking a myth than a proposition, is that algorithmic systems and data and the data that feed them are not neutral. The systems that we've looked at are trained on data sets that capture patterns and relationships that reflect past access to resources and past choices. For example, in a work context, access to work, pay, shifts. Again, you can see, I think, that really clearly in a work context. So by their nature, they will encode past patterns of inequality or privilege or disadvantage. And without intervention, they will learn from them. Those will be replicated and compounded and projected into the future, which is a big problem. Given the huge scale and pace at which these data-driven systems can work, and given that they stretch across traditional boundaries between work and home, and the dimensions of data are increasing too, this is an extra big problem. And also because, in a sense, the systems are meant to discriminate. They're designed to be finding patterns and similarities between people and groups of people. And for any former employment lawyer, at least, that's a big red flag. Another point here, before the final proposition, the way the systems work and the way they are used means that we're moving from an assessment of what a worker can do, what a person can actually do, to a prediction of who a worker is and what she or he is likely to do. The third proposition is information asymmetry. So this is already really, really pronounced at work, but we know and we've seen clearly through the case studies again that use of data-driven systems exacerbate this, as the systems simultaneously seek more information and give less information about what they're actually doing. And I won't go through our polling and information, but it's in the report. Perhaps we can put it on the chat and you can have a look at that. So against that background, that big background, we looked at the law really closely. Our full analysis is in our report, and I won't trouble you with that, but do have a quick look at it. But the findings in terms of the way the law worked are in summary these: that individual rights and remedies are not sufficient. What we've all really been talking about is structural intersection inequalities, which can result in collective harms on a mass scale, which can be projected into the future as they are amplified. And so our case studies felt in our sort of looking at the legal analysis is that relying on ex post facto individual claims isn't enough. It's not possible to even detect it, it's too late. And therefore a legal framework founded on that, based really on individual rights, won't ensure that these problems are identified and tackled and that the systems are well designed. I'm going to skip out the next problem because I can see the time. The next and move on to the fact that there are multiple forms of unfair discrimination, that they're not all caught by protected characteristics. I know legislation varies across the country, but it's and across the world. Some of these are benign, like what's your favourite colour, but some will be about your postcode and your voice, and therefore being wedded to particular axes of discrimination is not always the best approach. That's not to say it isn't hugely important in identifying and solving the issues that we're seeing. So we've seen that the current law has limits. We've seen and identified significant disconnects and contradictions, both within and between the legal regimes. And really what we're talking about is a kind of intersection in the UK at least, between an equality and employment regime and a data protection regime. It sits between them rather than being wedded to either or dealt with by either. We've seen powers of enforcement. We have those in the UK, but plainly they are that you've all experienced them too. There are also problem with powers and expertise. You need, as Benoit said, cross-disciplinary expertise. You need powers, also including powers to investigate and to set standards. And so against all that big background, we've come up with a proposal which is outline only, leaves a lot more work and development, and would love to know what you all think about it, which is a principles-based overarching framework which straddles the innovation cycle and sectors, although of course we do know that sectors will need specific guidance in addition to that. It combines forms of self-regulation and new duties. Outstanding among the new duties are new corporate duties, and in particular an algorithmic impact assessment. And within that we flag equality, because that's the thing that we've honed into is particularly neglected and particularly important in this scenario. So the duty is to embed a sort of systematic and dynamic duty to at the earliest possible stage of the innovation cycle to assess this, evaluate it, and then make reasonable adjustments for it. And against that background, we know that needs more work in terms of identifying the precise remit and thresholds. I'm sure there are lots of lessons that we could learn from you, but as a basis, we think that's a good place to start, and a good place to start a wider conversation, as Albert has said, with civil society and other stakeholders involved in it. We also make other recommendations, in particular on transparency and powers for the regulators and a cross-regulatory forum which we've proposed. But I think, Carly, I better stop there.
That's excellent, Anna. Thank you so much. I might just pick up on one thing you just said towards the end, and maybe turn it back to Benoit, if that's okay. You talked about a corporate duty, kind of imposing this duty at the corporate level, and I wondered, Benoit, if you could. It's a question that had sprung up when you were speaking, which is, the obligation in the Canadian instance is around public sector bodies procuring technology. We had a number of questions in the chat about this idea of opening up the black box and the explainability of systems, and to what extent that conflicts with corporate claims around intellectual property and kind of trade secrets. I'm not sure the extent to which the Institute for the Future of Work went into this as a challenge to that idea of a corporate duty, but I wondered, Benoit, if that was something that you had faced in your work, that is, when public sector bodies are procuring systems from private sector companies, what is the relationship between the two in fulfilling the algorithmic impact assessment, and what obligation is there on government to really get under the hood of the system that they're procuring?
Sure. So the directive, first of all, if the system is built in-house, which is the case for a lot of systems in the Canadian government, the source code has to be released. But as a transparency measure, I'm not sure it's really an effective measure. To the average citizen, what good is a pile of source code? You're not equipped to, understand it. So I like other types of transparency where it's in plain English. What is the system? What data is it using? How is it using it? Those types of discussions, I think, is more useful than the source code. That said, for the link with private sectors, so there's a lot of cases where you may procure systems to help you do your systems. And in that case, we require access to the source code. So that's something you need to negotiate to be able to have access to the systems in all its versions, because somebody could come, 6 months down the road and want to contest the decision. So as part of the contract, we require access to all the components of the system, basically since it was first deployed, so that you can re-verify a certain decision, recreate the conditions, and truly understand it. So not sure if that explains it or answers it.
Yeah, no, that's really helpful. Thank you. So we've got a scant 9 minutes remaining and a lot of questions in the chat. A couple of things that I wanted to pick up on. One is, I'm interested, Craig, and I want to connect this to Albert's experience in how you build public trust in the use of automated decision-making systems. And you kind of hinted at some of the critique that the New Zealand government had received on the Charter about, in particular, engagement with Maori communities. And I wondered if that's impacted your thinking going forward about how to better build trust with those communities. And I also wanted to ask Albert, what would it take, do you think, in the US context or in the New York context, to rebuild that trust, which feels like it might have been lost through a badly run process? Like, what would it take to start to build more trust in public sector use of these systems or these technologies? So Craig and then Albert.
Look, it's a really good question. I don't think we've lost the public trust. I should start in that by saying that. I think that there's a risk. It's a risk rather than an issue. I think, ultimately, I think that transparency is a key part of it that can help or hinder that trust, depending on what we're doing with them. But for us, particularly with that question of Māori, it's about how you enable greater participation for Māori. And I think this could apply to all communities, really. How do you enable much greater participation and decision-making and how these things are being used? So for our context, we're engaged in another process with Māori in a kind of data governance conversation where, Māori have largely been shut out of the government data system. Decisions have been made about and for Māori without any real involvement of Māori communities in those decisions. And I think that's a major problem for us. I think that does erode trust, and we're trying to find a way that enables much greater participation and decision making and how government is collecting, managing and using information that's relevant for Māori to make good decisions to further their own development. Algorithms fit into that. It's a part of that ecosystem, if you like, but it's a wider discussion that we're having. And I know Canada has had, it's very similar discussions as well. It's quite a pertinent discussion for a number of countries as well as Australia and others. And to me, that's how trust is maintained, is enabling that. And it's not just advice or, transmission of information one way from government to communities. It's actually genuine decision making, which is really challenging. That's actually really hard. In my world, you know, I'm a deputy chief executive in the National Statistics Organisation. There's legislation that protects the independence of the government statistician, and it's there for a reason, to make sure that the government statistician can say things that might be politically unpopular. So that independence is kind of, you know, is there and operates under legislation. So how do you enable co-governance and you know, co-governance and decision making with community members about how these things are done? Can be quite challenging. So it's sort of easy to say and hard to do, but I think ultimately that's for us how we're thinking about how to build and maintain trust and confidence, particularly with our treaty partners.
I think it's a very current conversation, in particular in the data governance space, isn't it? Which is like, how do you build participatory mechanisms for data governance? I'd love to follow more what's happening in New Zealand. I think in the context of work as well, Anna, there is this live conversation about how do you involve workers in a conversation about how their data is used, including by their employers, and make that a more participatory process. Albert, did you want to come in on that question as well?
Yeah, because I think this is a crucial question, but I think it's a second order question. And first we have to ask, should the public trust the ADS that are being used by government? And I think resoundingly, unfortunately, the answer in the US is no, because we're using, you know, criminal justice algorithms that have been demonstrated to discriminate against communities of color, against women, against non-binary individuals. We're continuing to use algorithms that are, you know, hidden by trade secrets protections. One thing I want to flag at the national level is we have legislation called the Justice in Forensic Algorithms Act, which would require any vendor that is using its technology in the criminal justice process to waive trade secret protection as part of that criminal proceeding. And that is, from our perspective, that sort of transparency is a bare minimum. But I also think that you know, another example is currently there's a bill pending before the City Council here in New York that would address algorithmic discrimination in hiring and employment. And in that measure, we've been doing quite a bit of activism, trying to ensure that we're including workers as part of those conversations, that we're giving organized labor an opportunity to audit these algorithms as well. But also, because of the nature of the American legal system, really focusing on the ability of the private bar to bring litigation on behalf of those whose rights have been violated, because we just don't trust that a public sector focused regulatory approach that depends on administrative agencies allocating the budget necessary to actually police these algorithms is going to be sufficient, because, you know, we're at a point where, you know, a lot of these agencies are struggling to keep up with how these algorithms operate, let alone create an actual enforcement regime. So we think that, you know, just given the limitations, especially in municipal enforcement, that we're going to have to use more private sector litigation, civil rights litigation, just as we have in fighting human discrimination.
Yeah, even though that comes with those limitations, which you yourself pointed out, and Anna did as well, around access to justice and the problem with ex post remedies. I mean, I think your point is a really good one, and it would be a great one to close on, which is you're entirely right to say that it's not about building public trust, but about building trustworthiness of these systems and making the case for why they should be trusted in. And I think that that is really the ambition, it seems to me, of some of these frameworks, such as algorithmic impact assessment, which is ensuring that the systems are trustworthy to begin with. I'm afraid we'll have to end it there. There's a lot of questions and conversation still happening in the chat. And Hannah, if you don't mind downloading the chat before we close, so we can follow up on anything that might be remaining in there, that would be great. Thank you all so much to our panelists. We really appreciate your time, and thank you for engaging with us. We've learned a lot, and I hope the audience has too. And this will be available in a recording, hopefully by tomorrow. You can find that via our Twitter account and on our YouTube page. Have a great morning, evening, afternoon, all of you, and thanks again for your time. See you later.